Joining me now is MSNBC legal analyst Lisa Rubin. Lisa, and I should say, I'm sorry, the approval dates back to 2000. Mifepristone has been FDA approved since the year 2000 for use as part of a two-drug and two-step process for abortions. So, Lisa, tell us what this ruling means. I know it just happened. You just now had a chance to read it. Lay it out for us. What does this ruling mean?
You're being generous by saying that I've had a chance to read it. I've had a chance to skim it. But what this ruling means is no less than a total disaster for America's women and girls. And here's why, Joy. The plaintiffs in this case, they asked for an order that would require the FDA to withdraw or suspend its approval of mifepristone. And according to people who are expert in FDA law, that's a process that likely would have taken several months, just given the way that the regulatory framework for the FDA works. Instead, what Judge Kaczmarek did here was stay the FDA's approval of mifepristone in 2000. And if you're asking yourself, what does that mean? It means it essentially freezes the world for the FDA before that September 2000 approval. It's as if they never approved mifepristone in the first place. Now, he's put a pause on his order for 7 days to give the FDA, represented by the Department of Justice, a chance to appeal it. But if this ruling sticks, this means a world in which mifepristone is likely not available throughout the United States, in which medication abortion is available only through misoprostol. That's the other of the two drugs in the regimen. That's a much more painful process. It's also laden with more risks than both drugs combined. And we're going to live in a world that is increasingly coming closer and closer to the one that Margaret Atwood imagined in The Handmaid's Tale. I never thought that I would see today happen, much less last June happen.
And the thing that, makes this so outrageous is that Republicans have long made the argument that their problem with Roe v. Wade is that it nationalized an issue that they felt belonged in the states, that they thought each little laboratory of democracy ought to be able to make its own rules for abortion, states' rights. But what this judge has done is to say, no, California can't make its own decisions. This drug is illegal in California. It's illegal in New York. It's illegal in Michigan, that just won back the right for women to have control over their own bodies. Illegal in Kansas, where there was a referendum in which people were asked, do you want to codify abortion rights? They said overwhelmingly, yes, we do. This judge has now overruled it. This, just from a federalism standpoint, is right. It really puts the lie, doesn't it, to what the right has always said they wanted. What they want is a national ban on abortion. This is a step toward that.
That's exactly right. And they won't stop until they get to fetal personhood. I'm really convinced of that. Joy, this is anti-federalist in two ways. It's anti-federalist because the Dobbs decision, as you recognize, said it was time to take the issue of abortion out of the courts and return it to the people's elected representatives. And clearly, the decision that Judge Kaczmarek has made today makes that impossible for people who live in staunchly pro-choice states like California and Vermont, but also in places like Kansas and Michigan and Kentucky. That's one way in which it's anti-federalist. The other way in which it's anti-federalist is, of course, with respect to the regulation of drugs, which is something that's always been left to Congress to decide and to the FDA. There was an argument that could have been made here that FDA regulations preempt state law where it comes to the regulation of medications, whether it's for abortion or for chemotherapy, that the FDA reigns supreme. That's an argument that affirmatively could have been made by the Department of Justice and wasn't, and is partially why we find ourselves here and why I am so frustrated and impassioned right now in talking about this ruling.
Let's talk about the pragmatic impact of this. If the FDA's approval is stayed, does that make it illegal to possess or sell or purchase mifepristone?
No, but, and here's what I'll say. The Comstock Act, which is a federal statute that's on the books, makes it illegal to basically send abortifacients or drugs that cause abortion through the mail. The Biden administration has a policy issued by the Department of Justice that says, essentially, we don't intend to enforce the Comstock Act. But that law is still on the books. It was one of the bases, for example, through which more than 20 state attorneys general threatened Walgreens when they announced that they were going to participate with the FDA in making medication abortion available through retail pharmacies. So there is a law on the book that makes it unlawful to send mifepristone, misoprostol through the mail. That the Biden administration isn't going to enforce it doesn't mean that it won't be enforced by a future president if it's not taken off the books by Congress.
One more question, and I'm going to bring in Alexis Minkos-Johnson in a minute, but I do want to ask you one more question. We know that the Supreme Court the six right-wing, the right-wingers in the majority on the Supreme Court, one of them, Clarence Thomas, with all his other ethical problems, has presaged that he would like to get a case that would also make birth control illegal. And we know that that was another Supreme Court ruling that he would like to get back, along with rulings on the rights of gay Americans to live their lives as well. Could the same kind of construct that we just saw here, a lawsuit that goes to a far right-wing judge, end up making birth control illegal? Could they use the same tactic?
I could see that happening here. And one of the things that they're going to do is try to pit two constitutional rights against one another. So, for example, while the right to contraception is rooted in the right to privacy, that's a long-standing Supreme Court precedent, have that bump up against, for example, religious freedom, which is what they've used in a number of these cases where they're trying to erode LGBTQ rights. The other way, Joy, that I think that they could effectuate that is by claiming the mantle of parental rights. There is a long line of Supreme Court cases that say parents have the right to raise their children in the way that they see fit. You see that parental rights framing undergirding a number of really pernicious statutes around the country, everything from CRT to gender affirming healthcare to now abortion too. Judge Kaczmarek has issued one of those rulings saying that Texas parents have a right to prevent their kids without consent from accessing oral contraceptives, for example, through the federally funded family planning grant program. So I can see a situation where through parental rights or through religious freedom, they're going to attack birth control next. And I think it's coming. You're right.